All right, I'm going to go ahead and get started so we can move on with the day. Yeah, so first thing is, as with every lawyer, there has to be a disclaimer, right? Is I am going through the basics. I am not trying to solve every problem, and everybody's circumstances are different, so everybody's estate planning is going to be a little different. So don't think that when I leave here today, I'm an expert, I'm ready to go. Hopefully we're just going to answer some basic questions so that moving forward, you know what directions you need to go. My goal is I'm going to ask sort of myself the common questions I've had over the years and give the answers. Your goal is to write down all of your questions, right? If you have a question about my question, write that down. And if I answer it, then strike it out. If I don't, then at the end, there'll be time. We'll just gather up all the questions and we'll answer them. So that's in part why you have paper there, is so feel free. And if I don't know the answer, I am going to tell you I don't know the answer. If I do, I will, and I'll answer it. I'm going to go through what I call the rich people spiel first. So a lot of people say, do I have to pay federal taxes when I die? The answer is yes. If you have over $15 million as an individual or over $30 million as a couple. And even then, you can avoid some of the tax if you set things up correctly. If you have this much money, you can just go ahead and leave. You need a downtown Seattle attorney because we're talking about legacy wealth. Or just write a big fat check to the church, pay off the mortgage, and we're all off to the races. What about gifting and federal taxes? How does that affect things? I always hear this, there's a gift limitation. The current gift limitation is $19,000 per year per person. So if you're a married couple, you can gift $38,000. Well, what happens if I give $40,000? Well, it counts against your $15 million. Gift away. The only thing you have to do is fill out an extra form if you go over that amount every year so the government can keep track of that whole estate exemption of currently $15 million per individual. So I'm guessing I'm talking to no one in this room because everybody's like, move on, we ain't got that kind of money. What about Washington state taxes? Well, that's a little bit different. So everything is exempt if you have a spouse. So if I pass away, my spouse gets everything. There's no Washington state estate tax. What's that? Well, if you want to get married to avoid state tax, that's on you. If you want to stay single and you have over $3 million, that's when Washington estate tax starts to kick in. And they kick in at 10% for the first million. So between $3 and $4 million, 10% of that ends up going to state tax. And it graduates upward all the way up to $9 million and above, which then has a 20% tax on it. So how does that work? Well, if you have $4 million, right, $1 million gets taxed at 10%. So 10% of $1 million is $100,000 in taxes. How do I avoid that? Give it to the church. If you give that $1 million above the $3 million to the church, then there'll be no estate tax. Easy peasy. If you say, well, okay, is there any other really way to avoid it? Well, I'm going to judge you because guess where the Washington state estate tax goes to? An educational trust fund to help with Washington state schools and education. So, you can avoid it, but do we really want to? And again, if you're married, everything's going to your spouse, there's no tax. So it's who's going to get it beyond that. And again, charitable giving will reduce that if you can get exemptions out of that. So that's for the people that have millions. For the rest of us, some of the common things that come up, I think, in one of the things that people will get into me debates about over hours is this thing called a reverse mortgage. What a reverse mortgage does is essentially it's like going to a bar and running a tab, except for the bar is a bank and they give you money every month. And then in return for them giving you money, they charge you fairly high interest on that money. And then when you pass, you have to pay it all back out of the equity of your home. So you end up getting a monthly check through this reverse mortgage. But if you have heirs or people that you care of or spouse that's going to need to live in that home, problems can occur because the way those work is you got to pay the money back, and the way that they get their money back is by forcing you to sell your home. So I don't like them, but they are a tool for people that's the only thing they have, and their Social Security is not going to cut it, so they have to do it. That's okay. One way to sort of avoid, if you don't have a spouse, right, and you're getting this reverse mortgage, but you don't want your kids to have to deal with the mess, well, you can tell your house and bequeath the house to the church and let Pastor Deb or Pastor Ollie deal with the reverse mortgage company after your death. Next thing, do I need a trust? That's like a really general term. I usually say it's like a car dealer. Like if you go to a car dealership and you say, I'd like a car. Sure. What kind of car would you like? And it's sort of the same thing with trust. There's so many different types of trusts out there. And because there's so many different types of trusts, and because there's so many different kinds of cars, sometimes car salesmen, I mean attorneys, are willing to sell you more than what you really need, right? In other words, a lot of people will go to this estate planning seminar they have in Montana or California, and you think, oh boy, I've got this 50-page trust, I'm set. Yes, you needed a 2-page trust, but yes, you're set for your 50-page trust, so, when Bill Gates gives you $50 million because he just met you, you're set with your big $50 million trust, when all you needed was just a little thing. So there's 2 main categories of trusts. One is what's called a revocable, meaning I can take it back whenever I want to during my lifetime. The other is irrevocable. In other words, I can't take it back during my lifetime. It's been funded, it's locked in place. If you're thinking I need a revocable trust, that's worth an individual consultation with an attorney, because once you make that decision, it can't be unmade. If I have $500,000 and I put it in my irrevocable trust, it stays there. And if I say, well, wait a minute, I want to help my kid buy a house, nope. It's stuck in your trust. If it's a revocable trust, and you say, hey, I put $500,000 in my revocable trust, you say, hey, I need to do something for my kiddo here and pull some of that money out, you can. So it's a big decision to go the irrevocable way. Why would I go irrevocable trust? Well, let's just say you ran a Ponzi scheme and you're trying to protect the money from creditors. Irrevocable trust is the way to go. Let's say you fell asleep at the wheel and you hit a pedestrian. Okay, before that lawsuit comes down, I may want to create an irrevocable trust to try to protect that money because something bad may happen. So very few situations are you going to want an irrevocable trust, because once it's there, it's there. You can't get it back. Some of the basics for a trust. Well, a trust is essentially its own legal entity. It has to get its own federal tax ID, just like a Social Security number. The trust is going to have what we call 3 essential persons. The reason why I do quotes is because the 3 people can actually be one person. Does this sound a little familiar in the church? The 3 can all be the same. And they call that a collapsible trust. So in other words, you can be what's called the trustor. That's the person who funds the trust. Well, how do I fund a trust? Well, you change the name of the ownership of whatever that asset is. If I say I want my vehicle to be owned by the trust, you have to go to the DMV, change the title ownership to your trust. If I want my house to be owned by my trust, you've got to go get a deed, file it with the county to say I no longer own my house, my trust owns the house. If I want my bank account to be owned by the trust, same thing, got to go to the bank, show them the trust paperwork and change that. And that's how you fund a trust. A lot of these people that go to these big fancy estate planning seminars in Montana or whatever, they make the mistake that they never move the assets over, so they have this big 500-page trust with no assets because it was never properly funded. So that's sort of the biggest step that you want to make sure that you follow through on, is I'm giving all of my stuff to the trust. The next person is what's called the trustee. This is the person who runs the trust. Okay, if my trust has $500,000 in it, how is it going to be invested? How is it going to be distributed? How are these things going to happen? And that's all the job of what's called the trustee. Then my favorite person is what's called the beneficiary. In other words, they're the person that we're doing this all for. So I'm funding the trust for the beneficiary. I'm appointing a trustee so that the trustee can give the stuff the way I dictate to the beneficiary. Now you say, well, what if it's all 3 Why would I do that? It's like saying I'm going to give my keys to me so that I can drive my car for my own benefit. That's exactly correct. Until I die. Now, somebody else has to be the trustee and somebody else should be the beneficiary. I suppose you could maintain yourself as the beneficiary if you say, I want to have a big mausoleum and have somebody come to my mausoleum every third day and clean it. You could still technically be a beneficiary, but somebody else has to be that trustee. And that sort of locks in place, right? Because now, by operation of law, it's no longer revocable. Because you can't revoke it because a weird thing happens when you die. You can't sign documents anymore. So it locks it in place. Now, why is that a good thing? Well, let's say, for example, I have a trust, and I say, well, I want to make where I don't have a trust, and I say, look, if I pass away, my money will go between my two kids. That's great. I trust them. Not really. I think my son's first trip would go to the Lego store with a big check, and it'd say, I'll take one of everything. Thank you very much. So I don't want him to do that if I was to pass away. So I can set up a trust, and then I would name my daughter, who's probably a little bit more responsible, as the trustee. And she could say, well, look, under the trust, brother, the only thing I can spend money on is car, travel, college, living expenses, all of these things. But yeah, Dad even put in here in little quotes, no Lego store. Sorry, I can't give you a check. So that's what a trust can do. It gives you a little bit more control during your life, and then it sets that up after death. A will can do the same thing, except for a will wants to just distribute and be done. Whereas a trust, that control can be ongoing as long as there's a trustee. Now, several things you want to think about, right, is usually trustees get paid, unless you've got wonderful kids who are just willing to do it for free. But professional trustees get expensive. Professional trustees make mistakes. So again, if you don't have that, we'll say millions, because I don't want to talk about tens of millions, because if there's anybody with tens of millions, then you should please go to an attorney in Seattle somewhere. But if you're in the millions category, you may want to think about a trust. If you're in the hundreds of thousands of dollars category, we're sort of at a maybe for a trust, because how much control do you need? How long do you think that those funds are going to last going into the future? Other reasons for trusts, again, are sort of, they call them a Q-tip trust, which is I want to avoid taxes at all costs. So in other words, we've got 45 million. And, well, the 30 million is the total exemption, and we still don't want to pay taxes. So you can set trusts up to do fancy things that basically say, well, I'm not a beneficiary of this trust until the trust gets below $30 million. Then, oh, now I'm magically a beneficiary of the trust in order to avoid taxes. Again, if you have that kind of money, this is complicated stuff, go see a Seattle attorney that specializes in that. Trusts for real property. This is a big one. If anybody owns property out of the state of Washington, you really want a trust. Why is that? Well, because again, the trust is its own entity, so the trust can go over to Idaho and sign documents to transfer that property. If you're deceased, you can't go over to Idaho, right, and sign documents anymore. And if it's just in your will, well, Idaho could give a crud what Washington courts say to say, hey, give this to my son. Idaho's going to say, we don't care. So you've got to file, again, documents in Idaho to take care of that property. So out-of-state property, hugely important to think about getting a trust. Other reasons, special needs trust. If there's grandkids or somebody that has special needs, you can set up a trust that helps them with their needs that aren't covered by federal and state programs. Those are also very technical, because if they're not done correctly, you could make them ineligible to receive those benefits. Blended families is another big reason for having trusts, right? I have 3 kids from a different marriage, not really, hypothetically. I have 3 kids from my first marriage. I get married, my wife has 3 kids from their marriage. And I've got, she's got Marcia, and I've got John, and we're the Brady bunch, right? But my dad was, again, super hypothetically, a multimillionaire, and I want that money to stay on my side of the family. Ooh, we need a trust for that, right? Because I know my dad would have said those millions of dollars should go to my biological grandkids, not your money-grubbing new spouse and her kids that don't deserve it, right? You would be shocked how often this happens in real life. And so a trust can establish that and keep things separated out so that we don't have that, what we'll call post-death conflict, where after you die, everybody's like, well, wait a minute, even though he wasn't my granddad, I loved him like a granddad, so give me some of the money, please. No, here's the trust, and it's dictating that. A second common category is what's called trusts in a will. It kind of sounds like pigs in a blanket, and it is kind of like pigs in a blanket. That little hot dog treat where you put the bun around it, right? This is a trust that actually gets inserted into your will so that you really don't need to do much with it when you pass. That's whoever you appoint, the personal representative or the executor, then sets up this trust. You wouldn't want to do that, especially in a real property situation, because again, we're a little late because you need to be changing deeds during your lifetime to get that out-of-state property there. But where would that be really important? Well, gifts to minor children, right? Nobody knows when they're dead, and we all know that when the kid's going to hit 18, right, and become an adult. So if there's little kids in your life that you say, well, look, I'd like to provide for them, but I don't want, Johnny, who's 16 and really loves fast cars, to get a lump of cash, because that's not what I want to do with it. So you can put a trust inside your will so that when you pass away, you'll be able to then have that same control. And the trustee is going to be, again, these are the things that the money can be distributed for. Education, toothbrushes, donating to the church, whatever that it is that you want that money to go to. And then, usually, after you have that provision for the minor children, there's what we call a sunset on the trust. In other words, at a certain age, you say, well, I can trust this child to get the money now. Commonly, it's 25. At least 15 years ago, it was around 25. Now it's increasing to like 30s, the more common age now. We had a client at our office. He kept coming in every 5 years to up the age because he just did not think his son was ready to inherit the amount of money that he was going to inherit. I think he finally topped off at 55, where he could then get the lump sum. The funny thing was, I didn't disagree with him. I knew his son. Probably a good call on his part. Because again, when you think about it, because I mean, you're going to know your grandkids and these people a lot better than anybody else, so you're going to be able to make that decision. Another very common thing that people set up is an educational trust within their will. In other words, they say, hey, look, I've been blessed. My parents were able to pay for my, education. I want to make sure to pay for the grandchildren's education. Or I know I've got a rich uncle who's single out in Massachusetts. He's 89 years old, 95 years old, and I'm going to come into a ton of cash, but I don't want that wasted's too strong of a term because people like yachts and cars and Lamborghinis. I think that's wasted, but some people don't. But I don't want it spent in a manner that would be inconsistent with my great uncle's wishes. So they'll set up what's called an educational trust, where the sole purpose is when I die, if there's money left over, the amount, whatever it is, gets distributed amongst the living grandchildren in order for them to have an education. Pay for college, pay for living expenses, pay for all of these different things. And then if one of the grandchildren doesn't want to go to college, fantastic. It still stays an educational trust. It gets distributed just amongst those that want to go to college. Or you could say, well, hey, look, what's wrong with you, Matt? You classist jerk. What if they want to go to trade school? That can go in the educational trust as well. So it can be set up in any which way that you want. And that's, again, why it's specialized. It's difficult to just say, hey, one size fits all. No. Nope. A trust can be whatever you want it to be and distribute things however you want it to be. So lawyers don't always encourage that because half the time you're going to be like a deer in the headlights. Oh, I'm in a law office. Oh, they're telling me this is the provision for an educational trust. Great, let's just do that. Nope, it's like a restaurant, right? Where you say the special of the day is the salmon with a dill pickle and jalapeno crust. You say, oh gosh, the salmon sounds excellent, but I don't want the dill pickle and jalapeno crust. The same thing can be done with trusts. You can say, hey, look, thank you for what it is you're offering. Can we customize it? I just want the dill pickle without the jalapeno. You can do that. You just have to explain that to your attorney that this is what I would like. Other main things. What is a living will? I absolutely hate that name. It's probably one of the strangest names that I've ever heard anybody call it. A living will is nothing but what we call an advanced health care directive. So the purpose of that is to just give instructions to those around you about what should happen when you can no longer express that yourself. When you're in a vegetative state, do I want to have nutritional supplements? Do I want to have water? Do I want to be on a breathing machine? And it lets those around you know whether you want that or not. It absolutely makes no difference if you're still conscious and you're still awake, because then you can tell the doctor, do this, don't do this. So this is only in that rare situation where you no longer have the ability to communicate your wishes. That said, hospitals are concerned about liability. Hospitals are concerned about getting sued. So if you have a very vocal child, and the vocal child says, I see that mom said here, take her off the feeding tube. No. If you do that, I will sue you. Guess what? You're going to be on the feeding tube, right? Because the hospital is going to honor that, the living wish. What about the flip side? Mom said she wanted to be on the feeding tube. Nope, take her off. I need the money. The hospital may not listen to that then, right? So the hospital is always going to sort of err on the side of life, because that's the reduced liability. What is a power of attorney? Power of attorney is another absolutely ridiculous term. Why? Well, because just because I give somebody a power of attorney, it doesn't make them my attorney. All it does is it says, hey, look, I'm giving you the right to act on my behalf for anything that you need of legal consequence. What does that mean? Well, there's two types of powers of attorney. One is effective immediately. In other words, the moment I sign the document, the ink's not even dry, whoever I've named as my power of attorney can then take that document, run over to the bank, cash out my entire account if they wanted to, and then go use it. Probably would result in a lawsuit, but not against the bank. The bank would say, hey, they had a power of attorney. So you'd have to go chase that person down, and even that person would say, well, look, it's a general power of attorney. It says I can do whatever I want. So the main thing is, oh, well, let's wait. Who are we going to make and give this great power to if we're going to do it immediately? So the next power of attorney is one that happens after incapacity. So again, my brain isn't functioning correctly. A doctor's declared that I can no longer make my own decisions because my brain got too fuzzy, or gosh forbid, I end up with dementia or something along those lines where I can no longer be trusted to use my own checkbook. Okay, now the power of attorneys for those is once incapacity is determined, now this person has the ability to go access your bank accounts, cancel your four Netflix subscriptions and all the other stuff if they need to. And that's the second way to do it. Now, two sets of individuals, attorneys really have a debate about this. One of them is like, look, you should just do every power of attorney should be immediately instituted, instantaneously. Why? Because they say, well, look, if you wouldn't trust them when you're incapacitated, why would you do that when you have the capacity, right? So it's, I think, I always see bad things, right? Nobody comes to me and to say, hey, look, that power of attorney worked out great. They took care of me and life was fantastic. No, it's usually, hey, look, my brother was the power of attorney and he absolutely drained mom's bank account. So I usually only see the negative side of things. But it's really important that you pick somebody that you can 100% absolutely trust. So if there's 3 children, obviously you have to pick the middle one. Do you need a will? Probably, but possibly not. Well, what is it that a will does? Well, a will distributes what are called probate assets. Well, that's a fancy term. What's a probate asset? A probate asset is your stuff, your accounts, your property, your cars, your boats, your Lamborghinis, all of those things. There does not include things that what I call an automatic beneficiary. What's an automatic beneficiary? An automatic beneficiary is when you sign a document that says, upon my death, this goes to this person. Examples of this are 401ks, IRAs, Roth IRAs, life insurance, bank accounts with a payable on death clause, jointly owned assets with right of survivorship, online stock trading accounts, TSP accounts, really anything where you said, this is who I would like to receive this after I die. Everybody's looking like, well, that's the majority of our assets. It is. So that's why sometimes you have to think, do I really need a will, or is the vast majority of this already taken care of because I've named beneficiaries and all these different types of documents? Well, what if I want those assets, my IRAs, my 401ks, to be distributed through my will? Long story short, bad idea, because those are tax-deferred accounts. Mr. Taxman says, oh, on your death, you want to take 100% of your tax-deferred account, cash it out, don't do that, right? And put it and distribute it under your will. So if you say, well, no, I'm locked in, I really want to do that, then that's a technical thing. You should go see a lawyer that can work with your plan administrator to figure out a good way to have that distributed under your will, because there could be significant unintended tax consequences. And if you put it in your will, I want my IRA distributed under my will, it doesn't work. It's not a probate asset, right? A probate asset gets distributed under your will. That IRA has a beneficiary. And if that beneficiary says, my great uncle Ted, who died 10 years ago, they've got to go find great uncle Ted's heirs to distribute that IRA 401k. It doesn't go to your will. It would have to say, my estate after I pass away, in order to go through your will. And again, it's not recommended. Are there tax consequences with my IRA, Roth IRA, 401k account when I transfer those? In other words, when I name them for my kids? 100% yes, but it's a little bit different. For example, if my IRA, if I have my son named in it, right, and he inherits it, and let's say, gosh, I don't know, 20 years from now, it triples in value and it's got $30,000 in it. No, it's better than that. But what happens then is it's going to be subject to what they call RMDs, right? You've heard of RMDs. It sounds like, George Bush's WMD. No, it's a required minimum distribution. So in other words, over a certain period of time, the IRS says, because you've tax deferred this account, you're going to have to draw it down and then pay the tax money back on it. Because remember, they're not tax-free, they're tax deferred. So at some point, the tax man gets his money. So in other words, it forces you to take those distributions even if you don't want to, and it forces your heirs. Could I, for example, say, well, I want 50% of my IRA to go to my son, 50% to go to my daughter? Absolutely, I could do that. Would it be a good idea? I don't know. It would really make my wife upset that I didn't give it to her. But that aside, right? You could do that, and they could each get 50%. Could I say 80% to my son, 10% to my daughter, 10% to the church? Absolutely. Now, I'm making more people mad, but you could do that. You can name different percentages in your IRA as a beneficiary, life insurance, whatever it is. Sometimes you'll get some pushback from whoever the plan administrator is. Why? Because there's one little tiny box for beneficiary to name. Right? Well, I can't fit 3 people in that tiny box. There's no reason, there's no legal reason why you can't add additional people if you want to, other than, well, how do I do that? How do I fit all those names in the tiny box? You figure it out. You change the form. It's okay. We can step outside the box. And then you can distribute it that way. What if I've already transferred my house to my kids? My car's already in my children's name. Then do I need a will? The answer is, if you have less than $100,000 in probate assets, no real property, no vehicles, no nothing that you really need to deal with, the answer is no. Your estate can be dealt with what's called a small estate affidavit in Washington. So in other words, all we've got to do is empty some bank accounts, clean up some stuff, pay off your credit cards. All of that can be done through this small estate affidavit, as long as you actually have a small estate, which is defined as less than $100,000. But what if I want one? Then get one. It's okay. There's no minimum. You can get a will and all you've got is $10 and you want to make sure that $10 goes to the neighbor. Fine, get a will. What happens if my spouse and I die and we don't have a will? Well, let's start with if I die while I'm married. What happens in Washington State if I don't have a will? Well, all goes to my wife. Will, no will, great. If I have a will, I can only give away 50%, right, of my estate. Why? Because it's a community property state. My wife is automatically entitled to 50% of whatever I have upon my death. I can give away the other 50%. Not sure how well, again, that would go over. Hopefully there is a heaven and I'm just happily laying there and not worried about life. But if I'm looking down, there's probably going to be some cursing. What happens if we both pass away? Think plane, train, automobile, something bad happens. We both die. It has to be, again, instantaneous. It can't be I die, 4 months later she dies. No, that's not it, everything that I had goes to her, and then it goes down from there. And the way that goes is they distribute it through this fancy word called per stirpes. What does that mean? It sounds something like I should go see a doctor for. Per stirpes just says, hey, look, if you have kids, it goes to your kids in equal shares. If you don't have kids, do you have parents? Nope, they passed. Okay, do you have brothers and sisters? Nope, they passed. Do they have nieces and nephews? No, they passed. Okay, does your mom and dad have, brothers and sisters? And on until they find heirs that can then take the money. That's usually, we've probably all seen on TV, right? Hey, are you, there's found money. All you've got to do is apply. I got $1 million from an aunt I didn't even know I had. That's how that happens. Is usually they didn't have a will and they were wealthy and they died and they couldn't find the heirs. So then it gets distributed in this weird per stirpes way. What if my only assets are my house, my pension, my IRA? Do I need a will? Maybe, but probably not. One of the things that you can do in Washington State is called a transfer on death deed. In other words, you're signing your house over to somebody else, and it only operates upon your death. So in other words, you put this will saying, on my death, the house gets transferred over to my kids. And that goes with the county auditor's office. And then when you die, the house transfers to your kids. The caveat to that is, guess who also likes to be involved when you start selling their collateral? It usually only works if you don't have a bank loan on your house. If you're paying a mortgage, the mortgage company has your house, and believe it or not, a trust. All of us say, well, it's a mortgage. No. Almost, I'd say 99% of what happens in Washington State is you sign a promissory note promising to pay Wells Fargo Bank $500,000, and their security for that promissory note is what they call a deed of trust. And when you sign that deed of trust, you have transferred your house as the trustor. Remember, we talked about that earlier. You funded a new trust that's held by the trustee, which is usually what they call MERS, Mortgage Electronic Registration Services, right? Meaning they can just give it to whoever they want to act as the trustee for the benefit of the bank. So when you die and you say, well, I have a transfer on death deed, it's going to go to my kids. Is it? Be careful, because the bank is the beneficiary of that trust. Now, could it go to your kids? Yes. They can refinance it through the bank. They could cash out their own assets to pay off the mortgage to get the bank out of the way. But the bank, it's not as simple as my kids will take over the mortgage. Why? Because the promissory note comes due when you die. So that money that you borrowed, whatever's left, is due and owing. So be careful with the transfer on death deed, because it may not do what you want it to do. What should a simple will cost? Sort of depends on which law firm you go to, how complex you want the will. For instance, if we talked about the pigs in the blanket, right, the trust in a will, it's going to get more expensive. If you say, well, when I die, I want to set something up so that my grandkids and their grandkids can have money, and I want that held in a trust, that'll be a lot more expensive. If it's simply, when I die, I want everything to go to my wife, and when my wife dies, I want everything that she has to go to me. Not speaking for her, but that's probably what would happen. And then if we both die, it should go to our kids. That's called a simple will, right? Because there's not a lot to it. You would expect for both, we'll call them both parents, right? But the couple should pay around $1,000 for those two wills, would be the expected cost. Can I pay more? Oh, yes. You can go to Seattle and pay $10,000 for a simple will. Or you could go to somebody local and probably pay close to that $1,000 mark. I like Adams and Duncan. They're good people. Anderson Hunter up in Everett, also good people. If you have millions, I would probably steer more towards Anderson Hunter because they have more experience dealing with that higher income bracket. If you have hundreds of thousands, I think Adams and Duncan is just fine. How do I donate $10,000 to the church in my will? I suggest you don't. Wait, what? Yeah, everybody got everybody's attention. Here's the reason why. In Washington State, specific bequests are supposed to be distributed first. So in other words, if I say $10,000, whoever is doing my will, my executor, my personal representative, that $10,000 check goes before to my kids in equal portions because it's a specific bequest. So why is that bad? Well, let's just say I make it to 104, right? And my kids are in their 60s and 70s. All I got left is $12K. And I said, hey, $10K to the church. I'm going to have two kids that are going to be like, what? We get the lousy $1,000 each and the church gets 10? Not a good idea. So percentages are the way to go. I give 10% to the church. I give 10% to WAIF or whatever organization, and you divvy it up percentage-wise because that makes it easy. It's just what is there for my estate? Make it easy. $100,000. 10% goes to church. Okay, 10%, $10,000. And your executive or your personal representative can then distribute those funds without the how much is left problem, right? It's just, well, look, I took care of my kids. They each got, 45%, and I gave 10% to the church. Great idea. But if there's only 10,000, I gave 10,000 to the church, my experience would be there'd be hard feelings. Unless you've had robust discussions with your children about what happens when I die. I like this percentage idea. Can I do that with my IRA and 401k? Yes. Again, you just have to name those beneficiaries. And your Boeing VIPs, IRAs, life insurance policies, all of that, can be divided up percentage-wise. I've heard probate is expensive and should be avoided. Is that true? Yes and no. Absolutely, if you live in the state of California and you have your $1 million house and you have your assets, California attorneys generally will charge a percentage of your estate to administer it. So they will take 10%. Well, 10% of $1 million is a pretty good for a day's work, right? You get $100,000. In Washington, if there's any estate attorney that says that they will take a percentage, just turn around, laugh at them, walk out the door. Generally speaking, most lawyers will do it on an hourly basis. And as long as the probate is what we'll call vanilla, there's not fighting heirs. Like one child is like, well, I want my Lego set. And the other one's like, you can't have it. It should cost between $5,000 to $8,000 to probate your will. So is it expensive? Yeah. I mean, $5,000 to $8,000 isn't nothing. But it isn't the 10% that California lawyers traditionally charge. And the last thing when it comes about, well, I want to keep my probate costs down. Let's talk about collectibles. The baseball card, that you've had since children, your autographs, your dolls, all of these things, the collectibles that you've got this amazing collection of that you want to pass down to your kids. Either name who gets those collectibles directly in your will, or prepare to pay a large sum of money because your executor or personal representative must then have it appraised and determine what the value it is so that the percentages can get divvied up from your autographs and your wills. So by the time that you value these collectibles, guess what? The Beanie Baby collection just wasn't worth it, right? It just doesn't math. So let's talk about the last thing, which is sort of what is probate. Probate is a process. It's not a thing. It's where your will gets filed with the court, and then whoever gets named as your personal representative or executor gets these things called letters testamentary. Now, what do these letters testamentary do? Well, they allow that person to sign on things after your death. It's one of the only ways you can do that, unless you live in Chicago, in which case you can sign amazing things after you die, including multiple ballots if you wanted to. No, I'm kidding. I grew up outside of Chicago, so I'm allowed to make that joke. It's a Midwest joke. But that personal representative essentially takes charge, and the first thing that they do after they get appointed as your personal representative is they start to do what's called an inventory. So what is that? Well, it means that they're supposed to list not every piece of china or grandma's old bird or, all those sorts of things, but make a general list of what there is to distribute and who is owed what. Credit card companies, all of these things. So you can make it easier on your personal representative by creating a list. This is what I have. Because what's the other thing most people don't think about? Oh, well, when I die, what happens to your AOL.com email account? What happens to your Yahoo account? What happens to my Netflix subscription? What happens to my DoorDash subscription? All of those things should get canceled because there's no public database where they say, oh, they died. Let's just take them off the list. Oh no, they're more than happy to charge dead people month after month after month until somebody calls and then shuts that subscription down. That can happen. Two ways to do that. I would say we'll call it the correct way would be that your personal representative contacts Netflix, shuts down the account, contacts Amazon Prime, shuts down the account, calls DoorDash. The other way is to cancel the credit card. That way those payments don't get made anymore. They get shut down. But if you say, well, look, I don't want those email addresses out there, right? Because very few people pay for email. We should probably figure that out, right? Well, what if my email has things that I don't want my kids seeing? Probably delete them now. just get rid of it. There's no point in that. Yeah, but that sweetheart from mine from 30 years ago sent me an email, so occasionally I like to read it. No, just delete it. Or have a paper copy. Make it easy. That way the email account can get shut down and nobody's spoofing you or using your email account after you're dead to try to run scams on other people. That's the only reason why I think you would say you'd want that email shut down, is because that email address is out there in the cyberverse, and there's plenty of people all over the world that would be willing to try to make a buck off of it if they could. So after everything happens with the PR, they go through, they say, okay, well, here's the assets, here's the debts, all the debts have been paid off, here's what's left, right? So most wills, you can add what's called a personal property designation, right? I've got an old vase of my grandmother's that was a family heirloom. It's probably worth $20 at a garage sale, but it's a family heirloom. So I could put in there, I want my son Anderson to have the vase located in the hutch. I've got a painting from my grandparents, so their great-grandparents' wedding. That one's kind of cool. So I'd say, okay, I want my daughter Ellis to have that painting. You can make a list of the things you want to specify. Go someplace. Why is that important? Your kids don't know what's important to you and what's not important, what you should keep or not keep. They just don't. And they're going to be missing mom and dad so much they don't even want to think about it. So then what happens? All these family heirlooms get sold at what? An estate sale with a little yellow tag. I guess you're dead, so you don't really care. But if you do care and you want them to know they should care, that personal property list is really the way to go to distribute those things. So once all of that gets distributed and there's the pot of money left, then what the personal representative or executor has to do is then distribute it out under your will. Hopefully the percentages, right? And then when there's nothing left, they go to court and then they close your estate. And that's the end of it. With a trust, right, it's different because the trust can keep going on until the purpose of the trust has been fulfilled. Hopefully some of you have written down questions, but those were the most popular questions that I had, so feel free. Let's see if we got answers.
On the last one, when you were saying the subscriptions and the accounts and everything else, in today's world, I've been seeing some action about you're having trouble because of two-factor authentication. And so how do you deal with that so that the people that come after you can actually access those accounts to close them down, to do whatever you need with them?
So one of the cool things is we live in Washington State. And Washington State has passed a law that says that your executor, who has the letters of testamentary, has the right to go do these things. Now, does that mean that they can do it the easy way? Go online and two-step authenticate? No. They're going to have to go talk to somebody at some corporate office somewhere to institute those rights. So what's the easier thing? Well, you'd better have your passcode written down somewhere for your kids once you pass away. Why? So that they can get into your phone, do the two-step authentication. So there's a lot more to think about now. In the old days, when the important papers are in the filing cabinet, right? 20 some odd years ago, it was that easy. Important papers are in the filing cabinet. We're good. Now we're talking about, well, okay, I don't even remember my passcode because I have biometric. I put it up to my face, and that's how I get into my phone. Well, try to remember your passcode, because I don't think that's something you want your kids doing, right? Oh, mom died! Quick, get her phone! Right? So I mean, you got to give it a little bit of planning beforehand. But absolutely, I mean, does your executor or personal representative have the authority to finish the two-step authentication if they have your phone? Yes, they have the legal authority to do that. Getting it done is a little bit different.
You the benefit or hazard of those?
Sure, let's go over that again. So a revocable trust, right, that's one where if I want to make a change for whatever reason during my life, I can make that change, right? And that's very, very, very common form of trust, because usually you're the one that funds the trust, the trustor. You're the one that is the one that's just, managing the trust, the trustee, and you're also the beneficiary. So in other words, I have this trust, but I'm really not doing anything different except for signing my name as trustee of the X trust dated whatever date. And then if you say, well, this isn't working, right? Or I made a trust and I named my grandkids, and oops, we didn't think we'd have another grandkid because my daughter was 50, but we've got another grandkid. We want to change the trust. The revocable trust lets you do that through an amendment to the trust. So a revocable trust can be amended and changed with time. An irrevocable trust is locked down. Once you form it, it cannot be changed. It's irrevocable. Now, can that be good in situations? Absolutely, like a blended family situation, right? Where on my side of the family, there was $1 million that came down to my side of the family. I don't know if me or my spouse are going to die first, but I have kids from a previous marriage. They have kids from a previous marriage. So I want to make an irrevocable trust with this inheritance to make sure that it goes down to the next generation or the generation after that. And that's probably one of the few situations where you'd say, I want an irrevocable trust. Or I gave the Bernie Madoff situation. Oops, I've been doing some bad things that I might get caught someday. I want to create an irrevocable trust so that it's going to be harder for anybody to come and take that asset from not me, because you're not a beneficiary anymore, right? From whoever those beneficiaries are going to be. If you're the named beneficiary, they can still come get it. Why? Well, because you're not entitled to anything if you've done bad things and they're trying to get some sort of remuneration for it.
Could you have two trusts?
You could have as many trusts as you want. There's no law against it, but I would be curious to know why anybody would want more than one. Like, what was I've never had that question, and I'm curious what the thought process behind it.
Right.
So that's not your trust.
You inherited your parents' trust.
Then that's not your trust. That's your parents' trust. You're just a beneficiary. No, it's still a trust, but it's not yours. That's sort of the cool thing about the trust, right? Is the trust lives on after your death, right? It still keeps its social security number. Nothing changes with the trust. It's who the trustee is, because you're deceased. You can't manage it anymore, and you're probably not the beneficiary anymore because, like I said, unless you have a mausoleum that you want taken care of, you're going to name other beneficiaries. But that trustee now, the trustor was your parents. So it's their trust. Then you're all trustees and you all get to determine how the beneficiaries get their money, but it's still your parents' trust, and all three trustees should follow whatever language is in the trust for distribution. Do they always do that? No. Do you have to always do that? If everybody agrees and everybody's in a great state of mind, sure. If everybody's not, and you're dragging your youngest sibling along, like, no, you're going to sign this, you're going to agree to this, and you're kind of, maybe they will, maybe they won't, you can do this thing called a TEDRA agreement. In other words, it's amongst the beneficiaries, you all agree, this is not what the trust says, but we all agree we're going to do it this way anyway, right? And that's called a TEDRA agreement. It's a way to sort of get around the deceased person's wishes, which I feel almost like dirty even saying that. You know? Well, Dad didn't want me to do that, but let's all agree to do it anyway.
But if you have yours, mine, and ours, say second marriage,
Yes.
you have yours, mine, and ours.
Yes.
And on mine, that money I inherited generations ago, I will keep wanting to pass down exclusively. But then there's our accumulated wealth, which should be disposed differently. Would that require two trusts?
No. It's like saying a choose your own adventure book is one book, but remember you get to turn a page and say, well, you can go to page 32 or page 64. You get to choose. Your trust can do the same thing. Your trust can say, $1 million of my trust goes over here to stay on my side. That said, I want $500,000 over here to take care of my spouse. You don't need two trusts for that. You can just put that all in the same trust. That's the customization of it, right? That's the, I don't want the dill pickle crust in the jalapenos, right? You can customize that trust however you want. But that's one of the things that you should really think about before you go see an attorney, or else you get more of a generic trust because they don't have any direction. So, well, what things should I think about? Well, that's exactly right. If you have $1.5 million, you know how much you have. I don't know how much you have. But if you say $1 million of that should go over here, then that's the discussion you have with the attorney. 500,000 goes over here. And then you can even put in there, okay, my spouse, I love them, but it's my second marriage, and I married a young lady who is 30 years younger than me. I don't know if $500,000 is going to, don't you dare tell my wife. I don't know if $500,000 is going to cut it, so I can also put a provision in my trust that says if the $500,000 doesn't cut it, you can then take some of the money from the $1 million to continue to fund to make sure that my young 30-year younger bride is taken care of. All those things can be done in the trust. Like whatever, like Willy Wonka, whatever you can imagine, right? You can do in your trust. It's just a matter of how am I going to communicate that legally, and that's why you have to work closely with an attorney. But keep in mind, that's what I said. The more you do those things, the bill is going to go up, right? Because now we're getting more complicated and more intricate in the drafting and more customized, right? Just like a car, you can go to the lot and you can get your basic model. I guess they don't have roll down windows anymore, but you can get your basic model and it's inexpensive. But once you customize, the bill starts to increase.
Okay, I want to talk about taxes. You can, as you get older, you've got this estate, and can you gift money without tax consequences to yourself or to your kids before you die? And then once you do die, I've read where you can, through the trust, actually cause harm to your kids by getting them in a higher income bracket. So, is tax, do you tax structure a trust?
You can tax structure a trust. That said, I think you must have missed the first part. The current exemption for federal taxes is $30 million as a couple. If you have over $30 million between the two of you, bless you, because you're going to leave the church in your will, you're going to pay off our mortgage, and you're going to go downtown to see a Seattle attorney to talk about intergenerational wealth. That's well above what we can offer in a seminar. And as far as can I gift? Yes, you can gift any amount you want, but once, as the two of you, if you gift over $38,000, you have to fill out a special tax form. Does that mean you get taxed on the gift, Answer, no, but it counts against your $30 million exemption. So if it sort of knocks that down as you gift away. In Washington State, there is an estate tax, and it's currently at $3 million, and the first million is taxed at 10%. So, and it's completely exempt between spouses. So if your spouse is alive when you're alive, it doesn't matter. $100 million can transfer to your spouse with no Washington State estate tax. It's only when it's going to go to someone other than your spouse that estate tax kicks in, and it goes to the Washington State Educational Trust Fund. So if you're thinking, well, what can happen and what are the tax consequences of that? It's not necessarily what's in the trust, because the trust can create income for your kids, right? But your trust, you can say, well, I don't want to do that because my child's a NFL player, right? And so they're already paying, they're in that 37, 38% tax bracket. So you can actually have your trust structured to say they can turn down that money and it just goes back into a pot for them, so they don't take the tax consequences in your trust. And then we talked about IRAs. And yes, that's a whole different thing. You're not going to put your IRA in a trust. You're not going to put your 401k in a trust, because that will create terrible tax consequences. And if you distribute those assets to your kids, then they are subject to the RMDs too, the required minimum distributions, which can create tax issues. So what do I do with those? That should be the money you're spending first in retirement. Your IRAs, your 401ks, all of that stuff. That's the stuff you should be spending first. Or if you want to be super clever, you don't mind paying the taxes now, you can roll those out of those retirement accounts, pay the taxes now, and then put them into non-retirement account assets. You can do that, but there's always going to be some sort of a tax consequence. The thing that I would, if I was trying to be very clever and I had a multi-million-dollar client, I think what I would tell them to do is, hey, look, you have a home that's worth, $1 million. You have a $300,000 mortgage, right? You have an IRA that's worth, $500,000. You can take those IRA proceeds, take the hit, pay off the mortgage, so now the house is free and clear. Why is that important? Because a house is one of the few things that the basis resets upon death. Well, what does that mean? That sounds really technical, but I like it. So if you bought your house for $300,000 back in the day, right? It's now worth $1 million. There's $700,000 of increased value, right? That's the basis, is your $300,000. That's what you bought it for. Upon your death, one of the jobs of the person representative or executive is to get that house appraised. $1 million. So now that basis resets, so your kids take it at a basis of $1 million instead of $300,000. So you've avoided tax consequences on $700,000 of equity, or growth, I guess would be the way to put it. So the house is a very powerful asset. Stock accounts, where you pay the dividends and you pay the capital gains when you trade, non-retirement assets, that cost basis resets. For example, I got really lucky. I bought GE during the Great Recession at like $4 a share because nobody wanted it. They were like, oh, it's garbage. I'm like, oh, I'm going to be smart. I'm going to buy 100 shares. By that $400 has quadrupled at this point, right? And if I bequeath that to my son, he gets it at the new quadrupled basis. So if he sells it the next day, there's zero capital gains tax.
We have like separate estates.
Mm-hmm. Yes. Well, you sort of. You don't want, a trust is attached to the individual. So you can have a marital trust, but usually in a situation where you said we both have estates, you're going to each want your own personal trust, because then it's going to dictate where your own personal estate goes. So if my wife inherited $1 million from her mom, right, and she wants to utilize it one way, I inherited $10 from my mom, if I'm lucky, then I want that distributed in a different way. We should each have a different trust instead of trying to mash it together. It can be. depending on what you want to do with it. If you're saying, I don't want to make an irrevocable trust because I might change my mind, right? And you're both trustees of the same trust. Guess what? When you die, guess who gets to make all those decisions? I never liked your kids anyway. Let's go amend the trust so I can get Matt's $10. That can happen. So that's why you might want to consider two trusts. You don't have to, but that's a way to sort of create that stability post-death, if that's what you're looking for.
Got 5 more minutes. Matt, at the beginning talked about law firms that you would recommend. Anderson Hunter was one. Did you say Adams was the other?
Adams and Duncan. And
Adams and Duncan.
Mm-hmm.
Does your law firm do this?
So here's the tough thing with my law firm. Yes, my law firm does do it. We've got 2 estate planning attorneys that's pretty much all they do, complex trusts, all of this good stuff. But we're over on Whidbey Island. So if you're going to do a will, then everybody's got to come over to Whidbey Island on the ferry boat, and come over for the initial consultation, do a lot of that work, and it's just I would say it's just not necessary. There's a lot of good estate planning attorneys in Everett. So if you're just like, well, we like him, we'd like his firm to earn the money, that's great. My partners are stupid busy. They're booked out until I think August or September doing estate planning work. So do I do it? I have done it. I've jumped in when my partner had her baby and she took maternity leave. I was doing all the wills and all the trusts and helping out. But I generally don't, because again, I'm booked out with just the work that I do primarily, which is real property and litigation. Mm-hmm. Yes. Yes. So the Washington State is really interesting. So if you said, well, look, thanks for Adams and Duncan, I called them, it's going to take too long. Thanks for Anderson Hunter, I called them, it's going to take too long. I want to just find my own attorney. There's a website called avvo.com that will list all the attorneys that have practice areas in wills and trusts. And you say, well, I want somebody with experience. Then you have to take your second step. You say, well, here's my list that I found from Avvo. This one looks like they're 12, so I'm not going to put that one on my list. This one looks like they're going to retire next year, which isn't going to help me because I want an attorney that can probate the will. So you narrow your list down. And then you take that and you go to wsba.org, and there's a lawyer directory. And you can put the name in the lawyer directory, and there's where you're going to find their bar number. Washington State is an incredibly interesting state because they start at 1 and go up. So the higher the bar number, the newer the attorney. And we're currently, I think, in the 80,000s. I've been doing this 20 some odd years and I'm at 33,000. So if you're saying, well, I want an attorney with some experience but not a lot, you're probably looking for somebody with a bar number in the 40 or 50,000 range. Yeah. When Shakespeare said, kill all the lawyers first, good luck, there's a lot of us.
So there was an app that somebody recommended, Wills and Trust app. And after I did it, it actually went to establish the family trust.
Okay.
And I got it registered.
Mm-hmm. A trust or a will? Okay.
I don't know, but I probably should have somebody check it out.
Did you fund your trust? So the house is in the...
I did it with my advisor.
Okay.
And the irrevocable trust in California protects assets for Medicaid. That's so difficult.
Okay.
So people don't have to use those assets. I mean, I'm just talking to you from California.
So that's way too generalized. Whoever told you that was not honest. Because you can become diseligible for Medicaid depending upon what you're receiving from the trust. So if you have that over $2,000, you're kicked, and now you've got to reapply. So it's not really about, does this document do what I want it to do? It probably does. It's more, do I have a trustee who's not going to inadvertently say, hey, let's put $2,001 in your account, because that will get you kicked off of Medicaid. So it's super technical. I think Medicaid avoidance just isn't. Yeah.
That's all of it.
Yep.
And as soon as you die, that trust becomes irrevocable, right? Unless you-
Yes, because you can't sign anything, so it's irrevocable. Yeah. So online stuff, I think it's absolutely fine, but you have to be careful when it comes to a will. A will has to be attested to in a certain format for it to be good in Washington, which means 2 witnesses have to watch you sign and say that you were in your right mind, that you did everything right, and then a notary has to notarize that those 2 witnesses are who they say they are. How?
I don't know, they have a contract, they have a contract.
No. So notary needs to see somebody's ID and say this person is who they say they are, and they have to stamp their notary on it. So the only way that app would work is you fill out the will, right? It gives you, here's the printed copy. You go take it to real live human beings. Oh, then it works. As long as it has the attestation and it's signed and notarized in what we call wet signed, so it should work. With a trust, the hardest thing with online trusts, again, you got to sign it and then you've got to fund it, right? You just if somebody gives you a trust document, like I said, you have the 300-page trust document. It's beautiful. You've signed it, but if you didn't fund it, it's worthless paper. Yeah. But that's the biggest thing people make mistakes of. They pay all this money, make an amazing trust, and then fail to fund. All right.
Good.
All right, we're good.